Welcome, everyone. Thank you for joining us today. I am Hannah Shea, World Law Group's Director of Business Development. You have joined us for a Greenwashing New Perspectives session this morning that is hosted by our intellectual property group. Before I hand it over to our panel, I just wanted to do a few housekeeping things. We do encourage you to turn your video on if you feel comfortable doing so. And also, if you'd like to rename yourself so that we know where you are joining us from, you can hover over your video, click on the three dots, and there's an option to rename, and you can add your firm name. You can also do this from the participant list. We are recording the session, just so that you know, and we will post it to our website within a week so that you could share it with colleagues who were unable to attend. With that, I'm going to go ahead and hand this over to Stephanie DeSchrijver, who is one of the co-chairs for the Intellectual Property Group, and she will be moderating our panel discussion today. Stephanie.
Hi, Hannah. Hi, everyone. Thank you for the introduction. Thank you all for being here today. And thanks for the World Law Group for bringing this event together. I'm very excited to have you all for this greenwashing discussion today. And as many of you know, greenwashing is a deceptive marketing practice where companies exaggerate or falsely claim that their products or services or policies are environmentally friendly. And this is a strategy that is often used by these companies to attract the consumer that is seeking more environmentally friendly options. And with this, the companies, they improve their public image and without actually making significant changes to their environmental practices. And we thought that greenwashing, we know that is much more broad than intellectual property. And this is why we have invited today some of the colleagues that have been very much involved in the greenwashing discussions. And we have here today Rakia from Arnold Porter in the United States. We have also Dr. Vip and Teresa from Taylor Bassing, and Danilo, my colleague here from Tosini. I'll let them introduce themselves, and they can also tell you a little bit more about themselves and their practice and a little bit about their experience in greenwashing.
Sure. Well, good day. It's a pleasure to meet all of you, and we are really honored to be asked to speak on this important topic. My name, again, is Rakia Pippins. I'm a partner in the Washington, D.C. office of Arnold & Porter, but we are a very large firm with over 1,000 attorneys with a lot of different practice areas. I think one of the reasons why I'm speaking on behalf of the firm today is that I co-chair our consumer products practice, as well as our consumer products and retail practice, which really represent industries in the U.S. that really want consumers to know when they're making changes that will protect the environment, but also has to manage a lot of legal and regulatory risks in the space. But we have a very large team of attorneys here who deal with greenwashing or environmental benefit related claims, whether from an advertising and marketing perspective, from a litigation perspective, or even from general environmental law, regulatory compliance considerations. So thank you for having us. And yeah, I will pass it on to the next speaker.
Yes, hello everybody. My name is Wiebke Baas. I'm a partner with Taylor Wessing in Hamburg, Germany, and I'm also very happy to be able to join you in this conversation. I'm standing in for Martin Prohaska, my esteemed Vienna colleague, who is in court right now at the moment and handling a big case. And I'm doing this together with Teresa, also from the Vienna office. Taylor Wessing is represented in many countries over the world. We're also over 1,000 lawyers. We're a full practice firm, and greenwashing is established, amongst others, in our IP team, where we're dealing with trademarks and unfair competition. But we do have a huge ESG practice area where we're also looking at regulatory or criminal law aspects. So we're really trying to advise our clients on the whole field and the whole bandwidth that green claims and green advertising comes in with. Well, happy to move to the next speaker.
Yes, hello everybody. Nice to meet you here. I'm, as Wiebke mentioned, an associate at Taylor Wessing Vienna, and I'm also stepping in for Martin Prohaska. And I've been assisting on various cases in the area of greenwashing, predominantly regarding green branding, which will also be the topic which I will be covering today. And I'm looking forward to our discussion.
Hi everyone, my name is Danilo. I am one of the partners of the Brazilian Environmental Practice Group of Tosini Freire, a Brazilian food service law firm. I work with Stephanie, my colleague here. I have been working exclusively with environmental matters for almost 15 years by now. And it is a pleasure to join this panel to talk a little bit about greenwashing, which is a very relevant subject. And I would like to thank Wordla Group and Stephanie for the invitation and for putting together this event. Thank you very much.
Oh, thank you all. I think we also have a brief presentation on the topic. Hannah, if you can, I don't know if you can share your screen already. But the first thing that I think would be great for us to understand is what is the legal situation in your jurisdiction about greenwashing? So do we have specific regulations and legislation already? What's the scenario now? And I know that Ricky also have a presentation, so Ricky, you can go ahead.
Sure. And I think it's important to start these conversations by acknowledging what laws and regulatory bodies can come into play. And I think one of the reasons Stephanie had the US go first is that you all know we like to sue people here. People get in trouble for a lot of things. And so I just wanted to take a few minutes to highlight where some of the standards are coming from that'll kind of guide the conversation from a US perspective. I wanted to highlight that, companies that are interested in making green claims and avoiding washing in the US have to really think about this because number one, both the federal and state governments here in the US are really focused on this issue. For those who are not familiar with the setup of the government and ways to bring actions in the US, we have a federal government in which there are instances where at a national level, green claims can be pursued, but also each individual 50 states has its own law that also gives people the ability to pursue what is considered greenwashing. And so when you have changes coming from both directions, it makes this issue really important. I'm also going to highlight that the regulatory bodies that create the regulations and laws applied in each of these jurisdictions are also changing the standards, and that has caused there to be a lot of attention to what's happening in the US because it will affect legal risk. And while I know we'll talk about this later, I think it's important to note that in the US, a lot of the risk actually comes from the everyday consumer who will pair up with attorneys who have what we refer to as class actions here, which can become sometimes the most financially adverse results for companies, in addition to adverse publicity, which I know all people involved in IP often want to avoid. So I think the biggest thing I wanted to accomplish with this slide was just showing you the breadth of spaces in which regulatory and legal developments are occurring in the US. It's all the way up at the presidential administration. I am holding my breath to see what happens over the next week here in the United States, but it is a priority that has been clearly emphasized. I will note that if there is a change in the political party here, it's believed that from a federal government perspective, some of the environmental enforcement will decrease, but it's definitely something that is being closely monitored. And then we have USDA, the Treasury, like all of these areas that people wouldn't think naturally would care about greenwashing have showed some interest in this space. And it's because you can get in trouble for lying, as I would say, or fraud with respects to carbon credits. There are different requirements for publicly traded companies on how they disclose what they're doing that can lead to liability. And then one of the most commonly referenced standards here in the US from a marketing perspective are the FTC's green guides, which are in the process of being updated and are expected to be released, the proposed final rule, either at the end of this year or early next year. And when you combine that with some developments that are happening at the state law, and in particular in California, it really leaves a lot to be paying attention to if you want to market here in the US. I think the green guides are of most importance when we deal with quote unquote greenwashing, because I think they most directly discuss what would be considered that. Greenwashing in the US is considered a pejorative term. It usually means you're being deceptive. And they're very clear about how you can avoid doing that, whether you're making general claims like eco-friendly or very specific ones about whether your product is recyclable, or you're referring to carbon neutrality. There are specific categories of claims for which the FTC asked for comments that we believe will be addressed in the new regulations that are issued. One big issue in the US is whether use of the term recyclable has to be changed from whether something can be recycled to whether it actually will be recycled. They're thinking about the fact that there happens to not actually be the circularity in the US that people would expect when making that claim. But they're also looking at having a formal definition for sustainable and considering whether some modifications to net zero and carbon neutral claims need to be made as well, just as an example. I think the other thing to note is that while what I discussed were the FTC green guides, which are just guidance from a federal perspective, there are several states in the United States that actually incorporate the green guides into their state law. So that's what gives individual plaintiffs in the states the ability to actually sue companies for violating what is only considered guidance that the FTC applies to at the federal level. And here I just list a few of the states in which that can happen. And I want to highlight that the way it happens, I think a great example, actually, current Vice President Kamala Harris, she used to be the Attorney General of California and was an example of an AG or state agent who was really going after companies that were believed to be engaged in greenwashing, here related to biodegradability claims, where the products actually weren't able to biodegrade within a year in a standard landfill. And what happens in the US is basically when you make a false or misleading claim in this space, there is the ability for a plaintiff to recover under our general unfair competition, or what we call UDAP, unfair or deceptive advertising practices statutes. And there are specific provisions in it that enable you to pursue money for penalties in that case. And this is just an example of some cases, whether it's eco-friendly or biodegradability, where that has happened. Very quickly, I just want to note that there are also very specific laws that are addressing claims like biodegradable, decomposable, degradable, et cetera, that are occurring in California. And if you go to the next slide, I'm flagging this more to let you know that you have to be very careful in the US to ensure you're getting true 50-state advice and not just at the federal level, because some of the laws differ depending on the location. So for example, I just showed you California. Then in Alabama and North Carolina, as an example, they have even more specific standards on what you need to comply with in order to use those words, and that you have to say that they're not recyclable or do not recycle. So I think often people are surprised at the cost of getting counsel in the US, but it's because of the breadth of regulatory considerations that come into play. I'm just flagging here that there's similar unique laws in states like Washington and Maryland, where it not only affects the standard, but it's limited to just food or beverage products. So it doesn't even apply to others, just some of the unique issues that can happen in the US. And so what I finally want to do before handing it over to the panel so we can have our discussion, and I know my colleagues are going to discuss some fundamental principles in their jurisdictions, is highlight that there are a broad range of other ESG-related developments that are occurring. I mentioned the FTC Green Guides updates. There also are state and federal laws related to your use of labor, and in particular, not using slave labor or complying with human rights in the US that can fall into that. Climate is definitely being monitored, and how you're reflecting your impact on environment, and just ensuring that you're aware that there are a number of different areas and regulatory bodies that could be triggered if you decide to make green marketing representations in the United States. And so with that, I will go to the next slide and pass it on to my colleagues at Taylor Wessing, or well, colleagues on the panel. Go ahead. Thank you.
Yeah, well, thank you very much. That was very insightful, and such a lot makes you a bit scared about doing this kind of advertising in the US. I wonder if anybody dares to still. Let's have a look how
it makes a lot of money for them, so I think it's worth the risk. But go ahead. Sorry.
Maybe that's even more scary. But then let's have a look at how things are going on in Europe at the moment. So what's in store in the EU? Firstly, at the moment, general unfair competition law is in place, and it is being regulated EU-wide by the so-called Unfair Commercial Practices Directive. And to put this briefly, what this directive basically says is that you must not make misleading claims, so don't lie, tell the truth, but also you must not omit information the consumer needs to make an informed decision. And these very general principles really are those that Europe-wide guide the case law and the local discussions. And obviously, when we're looking at this also throughout the jurisdictions we've got offices in, it's quite surprising, even though there are differences in detail, that the discussions also about what is accepted, what is a green claim, what is sustainable, how can I prove this, is quite similar, even though sometimes the routes to come to a decision are different. So let's have a look at what's ahead of us. And there are quite severe changes. The Empowering Consumers Directive, which, to be clear, does not only relate to green claims, but also to other ESG aspects. It will also deal with social aspects and with diversity aspects, but we will focus on the green aspect. It has been adopted and it will come into force in the member states in 2026. So the clock is ticking. So first of all, there will be very strict regulation on generic environmental claims. So basically, you cannot make such generic claims where you don't have any link to a specific product or a specific service, where you just say, we're green, we're sustainable. This does not really work anymore unless you can really prove that you're scientifically above any great standard. So you have to be basically perfect. And I think this is not going to happen. This is going to be close to impossible. So I think the EU is really trying to abolish these general claims. We're green, we're great, we're sustainable. This will be off the plates very soon. Secondly, there will be very strict requirements for advertising with future environmental performances. I mean, this also is quite popular. By 2030, we're going to be CO2 neutral. Maybe not. We still haven't done anything in 2029. So you can forget about that. If you advertise with future achievements, you will really have to set out a very detailed plan, which needs to be updated, which needs to be verified, so that step by step can be proven that you're actually on the path towards, for example, your carbon neutrality. Another heavy burden will be the rules on sustainability labels. I suppose just internationally, it's been quite popular, at least in Europe. You make up your little logo. It looks like you've got some kind of label, some kind of proof of excellence, and they're all made up. Quite often, a lot of effort has gone into this, but this will not be allowed anymore. The EU wants to abolish these. You can only use accepted Europe-wide sustainability labels. And if you want to invent a new label, it must be set up with strict rules. You need to draw up guidances. You will need an objective body that regulates these. So all these fancy little inventions, you've got a green leaf, you've got a green star, will not be permitted anymore. Well, what about sanctions? They will be established according to the Unfair Competition Acts of the nations, of the different member states. So that'll be the differences. Some have advertising authorities in Germany and also Austria. It's very much court-driven. Another thing I want to mention, that in the future, according to the Empowering Consumers Directive, compensation claims when it comes to carbon neutrality will not be accepted anymore. So basically, it's the trick, like we're not really carbon neutral, but we're paying some project and then everything will be fine. The Empowering Consumers Directive does not want to accept this anymore. So a quick look at the green claims, which is still be under discussion, which is going to make things even more difficult and strict. I only want to point out one aspect, the second last point here on my slide, the substantiation and pre-verification of environmental claims through a verifier assessment. So in the future, if you want to make these claims and if the Green Claim Directive comes into force, you basically can't say anything without having had it verified by a scientific body before. So watch out for this. It's still being under discussion, but I think it's pretty sure that this is going to come into force in about 27 or 28. So when I look at this, most of it has already been covered. And yes, so I think we can really move on to the next topic, as we have already spent quite a lot of time on this.
Hi, everyone. I'm gonna tell a little bit about the framework of greenwashing in Brazil specifically. First of all, I would like to tell you that we don't have here specific legislation on greenwashing. However, there are general provisions that are applicable to environmental claims, and greenwashing practices are deemed illegal and may be subject to the imposition of sanctions by the competent authorities, as well as to civil liability. I think it's worth mentioning that most greenwashing claims involve a consumer relation and are based in general provisions of the Consumer Defense Code here in Brazil. And this Consumer Defense Code basically prohibits false and abusive advertising of any kind that can somehow mislead the consumer about the nature, quality, quantity, properties, and other information about products or services. In fact, there is a decision, if you can move, um, there is a decision issued by the Brazilian Supreme Court of Justice that, at least from the judiciary perspective, it wouldn't be necessary to enact any specific legislation on greenwashing because the provisions of the Consumer Defense Code would be far enough to fight this kind of irregular practice. Here we also have the Brazilian Regulatory Agency for Advertisement, which is called CONAR. And this agency also provides for general rules to somehow guide and prevent misleading and abusive advertising. And these general rules may also apply to sustainability aspects. Once again, they are not specifically made for it, but it also applies to sustainability aspects. And compliance with the Consumer Defense Code or with binding regulations enacted by this Brazilian Regulatory Agency for Advertisement may result in the imposition of sanctions, such as warnings, fines, among others. And it interests to mention that in kind of a response to the rise of greenwashing issues around the world, this Brazilian Regulatory Agency for Advertisement, together with the World Federation of Advertisers, have published a document called the Global Guidance on Environmental Claims that basically provides guidance on how to best communicate sustainability. This is a non-binding document for sure, but still it's kind of an attempt to contribute and to the prevention of greenwashing practices. So this is very briefly what we have from this consumer's perspective. But we also have discussions on greenwashing from the investor's perspective. Although less common than the consumer discussions, obviously. So we have here the Securities and Exchange Commission of Brazil, who enacted a rule in 2023, which provides for guidance on disclosure of reports containing sustainability-related information. And the purpose of this rule is to basically increase the transparency and the reliability regarding the disclosure of sustainability information, and also of policies and procedures adopted by the organizations to somehow deal with or to mitigate the impacts related to climate change and to social and environmental aspects. It is also important to mention that this Brazilian agency enacted a rule in 2022, which establishes in general terms, but that is also applicable to sustainability claims, that it is considered as a gross violation to provide false, inaccurate, or misleading information to the market or to the competent authorities, which may be punished by warnings, fines, and so on. And at last, I would like to tell you that there is this bill of law dated 2021, which basically aims at prohibiting advertising that promotes the positive environmental image of companies when such companies have environmental liabilities, such as judicial or other kind of proceedings involving environmental violations. However, there has been no progress in this bill of law since 2021. And to be honest with you, it's kind of a relief because, at least in my opinion, the existence of possible environmental liabilities doesn't mean that you can't make environmental claims, provided obviously that the claims are not impacted by the existing liability. So I think that for now, this is it. This is a broad overview of the Brazilian framework about greenwashing. And I will hand over the next speaker.
Thank you, Danilo, and thank you, everyone. I think that was very useful. And from my perspective, based on what you all explained, it seems very clear that United States and Europe, they're very active in terms of the regulations, in terms of what's next in greenwashing. And at least, I don't know if Danilo agrees with me, but Brazil is a little bit more reactive on the matter. But we are looking at it. I think many countries in Latin America are quite similar in terms of the regulations on greenwashing, that we don't have that many specific regulations because we use what we already have under our law. And given also that the EU directives are coming into force, and I know that we already talked a little bit about environmental claims, but I wanted to understand a bit more on green brands. And I know that Teresa has a great expertise on the matter. So, Teresa, if you can give us your perspective a little bit about the green brands and EU directives that are coming into force in 2 years, that would be great.
Yes, thank you. I think Vipke will start with a brief introduction into the topic, and I will then go on with discussing some cases.
Yes, so I will just continue briefly and having a look what green brands will be under the Empowering Consumers Directive. And you would think that regulation of unfair competition issues don't have any impact on green brands, but to the contrary, they have, because the Empower Consumers has a definition of what is an environmental claim. And it states an environmental claim means any message or representation, including text and brand names, labels such as brand names, which state or imply that a product category is less damaging to the environment than others, or has improved impact on the environment over the time. So clearly, the directive also tries to regulate brand names and labels. And this does have a huge effect because the Empowering Consumers Directive also prohibits the self-certification of sustainability labels. I mentioned this previously. So if you've got a nice logo, which somehow looks like it may be a self-invented sustainability label, it will not be possible anymore. So you will really have to very closely look at the trademarks you have in place and you're going to use, and whether they may in the future fall under the limitations of the Empowering Consumer Directive. So we do have some companies where, when I look at the logos they're using, and which are all over the place in the country, it's very clear that they will have to put on a lot of work into changing this and to make this legally proof once the directive comes into force in 2026. But Teresa, now let's get into detail.
Yes, thank you. Can we move to the next slide, please? Thank you. So to begin with, I would like to show you some cases from the registration procedures of the European IP Office, which is responsible for the registration of European trademarks in Europe. And as we can see here, there is some established case law, and we can see that applications which consist solely of environmental elements, such as the terms green, eco, and bio, and are combined with maybe generic terms which merely describe the goods or services which the trademark is supposed to be registered for. This might pose a serious problem in the registration proceeding, rendering the or leading to the trademark being refused. So, for example, I'm not going to speak about all the examples which we have here, but maybe just some. For example, eco-vinyl has been refused by the EU IPO because it's quite obvious that the term eco merely describes a positive aspect of the term vinyl, which was a trademark meant for records for vinyls. As well, we can see with the trademark eco-trend that the EU IPO holds that the term eco is an abbreviation of the term ecological, and it merely describes the goods and services. This is quite interesting because there has been a recent Austrian decision, which I will be speaking about in a bit, as for the term ecological. Now, I think we can move to the next slide. Then we have some more examples as for various slogans. We can see that the EU IPO is applying a strict standard as for slogans. And for example, the trademark "Save the Ocean" or "Because there is no Planet B," which is a famous slogan of the Fridays for Future movement, has been refused as a trademark because it simply lacks distinctiveness, which is necessary to register a trademark. On the other hand, we have some examples of trademarks which have been registered and which may show what is actually the right way forward. For example, the trademark "Revolution." It is imaginative. It's sort of a wordplay. Something similar we have done for a client recently, that we have registered a trademark which was sort of a wordplay, and where the sustainability aspect was not so obvious. And as for the trademark "Climate Neutral," you might know it. It now is used in the form "Climate Partner" for various certification projects. I would just put the question in the room whether this trademark would be registered in this form and with this wording at the present state, or in the future with the upcoming EU regulations. Thank you. I think we can move to the next slide. Yes, so here are also some examples which are specific for Austria and Germany, but might be noteworthy. And in particular, I would like to point out the trademark EcoBox. So as mentioned previously, in view of the EU IPO, the term eco stands for ecological. But on the other hand, the Austrian Higher Regional Court of Vienna has ruled recently that the term can actually stand for both economical as well as ecological, and held that this trademark is distinctive for building materials, because the other term "box" is not descriptive for the goods. It predominantly means, for example, carton box or loudspeakers, but there is no obvious association with building materials. So it appears that the way forward is to be sufficiently imaginative and avoid a direct link with the sustainability aspect and generic terms in the trademark. Thank you. I think we can move to the next slide. Right, and as was already mentioned in the beginning, there is also the topic of deception when it comes to green brands and misleading the consumers. For example, when we have a trademark which implies an environmentally friendly product, and the products are actually predominantly made, let's say, of plastic, or when the trademark suggests an environmentally friendly service, but the service, in fact, let's say, relies heavily on fossil fuels, this might be perceived as a misleading claim by the consumers, which is also a ground for refusal. It is always relevant to assess the deception in relation to the classes of goods and services for which the trademark is registered. So of course it is very important when drawing up a list of goods and services to have this aspect in mind and avoid, for example, as we can see with the trademark paper to paper recyclable, and then in fact the list of goods contained terms such as plastic packaging or plastic cups. This might be a problem in the future.
Thank you, Teresa. I was going to ask about some consequences of greenwashing, but I think maybe we can move for you sharing some of interesting cases in your jurisdictions, and then we can go back to the discussions about the consequences, because I think most cases will have a perspective as well on some of the consequences from the consumer image and perspective, as well as from a regulatory perspective. And then maybe, Ricky, you can tell us a little bit more about the cases that you have in your jurisdiction, your experience.
Yeah, so one of the things I just want to flag quickly before going to the next slide is that, I mentioned all the different states that exist in the US. And so what you often find is that companies will create more of a, I hate to say race to the bottom, but they find the most restrictive standard and use that for selling it everywhere, because it is almost impossible to control which state your products go to in the US, especially when you're selling online. And so I'll just highlight is that there are several cases that have happened in the US that really are related to consumers filing class actions under state law because of what are viewed as overly broad eco-friendly claims or contradictory practices. And it has hit cases that involve statements like sustainable or clean. Natural has always been a big issue here in the US, more because of the processing methods, and recyclable. And what I want to be careful about highlighting specific client companies, but I would talk about the concepts a little bit. There was a major litigation in the US that dealt with a retailer that had a tagline for what they considered to be their sustainable products here in the US. And they were sued because the products that were placed under that tagline in their stores were not believed to meet the standard that consumers understood the term like sustainable to mean. And this was despite the retailer actually defining sustainable as meaning that it didn't have certain harsh chemicals in the products, or trying to be specific about in the personal care product category, the definition. And I think this is a reminder that in the US, if you're going to define what you mean by a term like sustainable or eco-friendly, you have to do it in very close proximity to where the term is. Otherwise, your qualifier can be viewed as too far away to really avoid misimpressions. I have here some really notable examples of cases in the US where companies have been held liable for purported greenwashing. I have names here so that you can find the cases, but I don't think that these companies necessarily were bad actors. I think these are common issues that can come up when companies are not aware of all that their companies, all that their employees are doing throughout a company. So if you take the Keurig settlement for here, this is really interesting in that they were held liable for in the SEC, similar to what the Tozini colleagues were mentioning, because of representations made in their annual reports about their goals and from an eco-friendly recyclability standpoint. They had previously been sued in the US about whether their pods were capable of being recycled. And what's believed to happen is that it triggered scrutiny of how these statements had been made in their annual reports to the government as a publicly traded company, and it led to additional liability. I think similarly, the JBS Foods example, which was actually brought by the New York State Attorney General, is a good example of where watchdogs or state agencies can go after a company that's making environmental beneficial claims when they're in an industry that is believed to inherently not be capable of protecting the environment. So here, when you're dealing with cattle, which are believed for all of these different reasons to have high levels of emissions, it's just the nature of the industry impacts the environment. There has been scrutiny on companies trying to speak to being net zero by a certain point without real tangible examples of their steps towards that goal being available for people to review. And I just want to highlight that as a scrutiny that should be placed if you're in an industry that is considered to have inherent environmental benefit. The third one that I'll mention is more from greenwashing based on the labeling of products. So the FTC went after a number of retailers and like upholstery and like blanket towel manufacturers for calling rayon products bamboo because of what consumers believed bamboo might be associated with as being more eco-friendly. And so here they went after the companies on two ways. One was stating that if you use the term eco-friendly, what we know about how rayon from bamboo is made, it inherently undermines the truthfulness of it. The second is that in the US, there are very strict standards on how you label textiles. And you can't like make up a new name like bamboo. It had to refer to its rayon form. It's just a reminder that if you're dealing with a form of quote unquote greenwashing, there are multiple traditional unfair and deceptive advertising practices standards that can be used to go after the practice. I'm going to be very respectful of time, so I'm going to pass it on to colleagues to highlight issues in other jurisdictions, but I'm happy to discuss any of these more towards the end or if someone wants to follow up. Yeah.
So thank you very much for this very exciting overview. And I think it's so amazing to see how kind of internationally we're always discussing the same issues, and every company is trying to basically to try the same to promote their products. So I think we're really having an international issue here, which we need to solve altogether. So I only wanted to point out two cases. The first is we just had the first federal Supreme Court decision in Germany. And it is about Katjes. I don't know if you know Katjes Haribo. It's a very popular sweet. And they had this nice advertisement in a magazine, which is directed at people working in the food industry, saying Katjes also it's basically it's also it's tasteful also for the climate. So it's basically saying also the climate is enjoying these sweets, and they claim to be climate neutral. And this advertising was deemed to be okay by the first two instances, and it was finally squashed by the Federal Supreme Court because the court said, well, the term climate neutral is ambiguous because it can be understood both in the sense of a CO2 reduction, or it can be understood in the way that the reduction is achieved by a mere compensation. And if this is unclear and if it is ambiguous for the consumer, the clarification of which alternative applies must already be made in the advertising. So here, as you can see from the picture, they applied a little a link where they were given more information on how the climate neutrality was achieved. And the Federal Supreme Court was very clear and gave a lot of guidance because there has been very differing case law on lower court level. Let's say this is not enough. Explanatory notes elsewhere are not sufficient. You must put this right on the top of your advertising when you're using this kind of ambiguous terms. I also want to mention another decision, which I've not on the slides, but which also is very far-reaching. We had a regional court in Karlsruhe, and they also had to discuss climate neutrality. Which in that case allegedly was achieved by the company investing in forest carbonization products. So they said we're climate neutral because we have spent so much money that this forest somewhere in the rainforest is being kind of rebuilt, restructured, or saved. And here the court says this is misleading because scientifically it is impossible to achieve any positive carbonization effect by paying money into forest projects because we do not know how long the trees will live. It is impossible to really calculate how much carbon will be offset by the support of these forests. So, and there have been a huge amount of projects, and a lot of money was made with these projects as people could use them to advertise their carbon neutrality. And here the courts have been very strict now and saying it's not possible. So you can see that a lot of change to advertisements is being done in Germany at the moment. It has not been tested before the Federal Supreme Court yet, but I'm pretty sure that this strict approach is going to be upheld.
Here in Brazil, we don't have many judicial proceedings involving greenwashing, I would say. I have identified three more relevant cases that I would like to briefly discuss with you. Just to let you know, the first one, actually, we're talking about uh, civil lawsuits filed by individuals against Apple. Two consumers filed, each of them, a lawsuit against Apple, arguing that the company was harming the consumers by selling cell phones without the respective charger. The initial petitions are not based in alleged greenwashing practices, but rather in aspects related strictly to consumer relation. But what is interesting here, and this is why I'm telling you about this case, is that Apple filed its defense, saying basically that, among other aspects, for sure, the charger was not sold together with the cell phone due to the company's concern with environmental aspects, aiming at avoiding negative environmental impacts. And the judges of these both lawsuits said that there was no evidence that the sale of the cell phone with all the chargers was linked to a sustainability practice. And based on this fact and also in other arguments that were raised, the judges decided that the charger should be freely provided to the plaintiff. In this case, the environmental aspect was not used to try to promote the sale of a particular product or to promote the company's reputation, which would be a classic greenwashing case, but rather to try to justify what was considered an inappropriate practice adopted by the company. Just to let you know, the company appealed from these decisions. One of the appeals has not been ruled yet. The other one was ruled in favor of Apple, reverting the first instance decision. However, the reversion of the decision was based in aspects other than greenwashing. And the other one, the civil lawsuit filed by the public prosecutor's office against a company called Monsanto. Basically, Monsanto launched an advertising campaign defending genetically modified soybeans and highlighting that the positive aspects of the pesticide use. This happened in the early 2000s, if I'm not mistaken, but when, at least in Brazil, there was a significant debate between supporters and opponents of GMOs and pesticides. The public prosecutor alleged that the company was praising products without highlighting the environmental risks, which could be could potentially mislead third parties, making it partially omitted and therefore misleading advertisement. But analyzing the situation at the time and the content of the campaign carried out by the company, the courts understood that there was no misleading advertisement, and they emphasized, and this is relevant here, that the company was simply conducting an institutional advertisement to defend the use of its product in a context where the potential negative uh, effects of the products were well known to the public. Uh, and this was precisely what was being discussed at the time, the pros and cons of using GMOs and pesticides. So the court concluded that this situation here did not constitute a greenwashing practice. We have also proceedings in the administrative sphere. So, as regulatory agency for advertisement in Brazil, CONAR is responsible for recommending changes in advertisements or their suspension whenever it is identified misleading or abusive practice. The administrative proceedings may be commenced by representation of CONAR itself, consumers, competitors, among others. But the representations before CONAR, what we have seen here is that they are more commonly made by competitors. And this is interesting because it indicates that, at least until now, more than a concern raised by the consumers and by the regulatory agencies themselves, greenwashing practices are being somehow followed more closely by the competitors from a perspective of kind of a market protection. And just to give you some broad information on proceeding files before this regulatory agency in Brazil, in 2022, we have 9 decisions related to sustainability claims. 7 of them require the advertisement to be amended to become somehow to say the truth about the facts that were explored in the respective advertisements. And 2 of them recognized that there was no misleading information. And last year we had 7 decisions on this matter. 2 required the advertisement to be amended to become adherent to the facts that were explored, and the other 5 decisions recognized that there was no misleading information. And what we have identified is that most of the decisions issued by CONAR are related to the automotive, the cleaning products, and the personal care industries. So I have just to mention here, I brought some examples to you, and in the benefit of time, just to go very briefly through one of them. We have in one of these cases a decision issued by CONAR concerning an advertisement that mentioned super green tire without any further explanation of the product. The company claimed that the name was given by the manufacturer because the product supposedly reduced fuel consumption, but there was no proof of that. So CONAR required the company to amend, to change the advertising campaign. In the other one, there was this advertising mentioning the terms, the expressions eco and ecosystem to promote certain models of vehicles. And CONAR once again required the advertising to be changed because there was no evidence of any kind of fuel economy nor of air emission reduction. Coming to the cleaning products industry, we have this example here of a decision regarding an advertisement that mentioned the terms again eco and 100% green. And CONAR required once again advertising to be changed and considered that the fact that the product is has some benefit from the environmental perspective does not eliminate the other environmental impacts of the manufacturing of the products. So I think that's pretty much it. We have other two examples, but I will hand over to Stephanie in benefit of time.
Thank you, Danilo. Thank you all for all very interesting cases. And because we're very short on time, I just wanted to see if we have any questions from the audience. I don't know, Hannah, if you have received any questions.
Well, I have one question, if I may, then. Perhaps mostly directed to Vipke. and Teresa. That is, you gave examples of recent German decisions, and could you reflect briefly on the sanctions, or if any, related to those latest decisions, and perhaps comment briefly on what your take would be if those had been subject to the new rules and sanctions under the coming directive. Thank you.
Yeah. So at the moment, the sanctions are basically that you have to cease and desist this kind of advertisement, and which, of course, when you've got it on products then it is already very expensive to change this. We do not really, at least in Germany, we do not have a rule for fines when it comes to misleading advertising. It's very difficult to establish that damages have to be paid. So it's rare that you go after damages. But when it comes under the new regime, when the EU directive comes into force, they are especially the green claims. I mean, they have sanctions and penalty payments, which go up to, I think, 4% of the turnover. So this is going to be very painful, potentially, and it's something which I also would like to ask you and also the others. We are at the moment, we are start to also discuss not only greenwashing, but potential green hushing, because we've got clients who've reached the point where they say it's so dangerous what's ahead. We don't put any comments anymore on the products. And we really, unless you've got something in writing which you can delete at the same time, or just on the website which can immediately be deleted, you will simply stop. And then you've got the marketing department or the lawyers say you can't really do this anymore. Marketing department doesn't do it anymore, and management, they say, well, if you can't market it anymore, we're not going to pursue these environmental friendly products. So I think this is a debate we just start to having, if maybe it starts to be a bit counterproductive. And the opinions are very divided. Some say there's so much money in it. I think, as Rakita said, it's just so effective. People will continue doing green advertising. And others say people will stop it, but they will also stop their green efforts. So that remains to be seen.
No, there was. Thank you, Vibke. That was exactly my point and my guess, that because that is, I think, the big transition we'll be seeing for our clients who are active on the EU market. That perhaps after the courts have been started looking at it, I'm not sure that the court practice or actual current assessments of what you can and cannot do will shift that much, but the big difference is in the sanctions. It will be a whole other ball game in terms of risk. Well, thank you.
And I mean, also with the claims, considering that there are claims which will need to be scientifically proved in advance, that the EU Commission estimates that this can cost between 500 and 50,000 euro. I mean, for an advertising claim, who's going to do that?
So just to follow up on that, it means nobody's trying to figure out what actual damages are, right? It's more like just putting out sanctions without trying to attribute what the actual impact of the damage could be.
Exactly. So it's more like you're going to be penalized based on your financial success.
So the recent modus operandi of the EU legislator has been for the last couple of years to pretty much copy the what we formerly only knew from the competition law aspect type of fines into every regulatory sort of new aspect of this. And this it's a high risk development we're seeing.
Well, I want to thank you all it was a very rich discussion. Thank you for our panelists for joining us, and all of you. And feel free to reach out to them directly if you have any additional questions or for discussions. And thank you all for being here today with us.